I'm Dan Antonelli. I'm an estate attorney here in New York City, and today I'm going to answer the frequently asked question, what is a will contest? Simply put, a will contest is where one person tries to probate a will, meaning they ask the court to say that this will is the valid last will and testament of a decedent. And another person comes forward and objects to that. They say that is not the valid last will and testament. And there are multiple bases on which you could claim that a will is not valid.
There are 5 legal bases for objecting to a will. They include undue influence, lack of testamentary capacity, fraud, forgery, and revocation. Lack of capacity is when the testator does not possess the requisite capacity to sign a will. So, for example, the testator does not know what their assets consist of and who their family members are. Undue influence is really twisting somebody's arm to make a will. It's when the testator is not making decisions that they normally would make without that person's influence. If you have a will that is the product of undue influence, that will really reflects the third party's wishes and not the testator's wishes. Forgery is when somebody else signs your name for you without your permission. Revocation is when you essentially revoke your will. So one way that you could revoke a will is by physically destroying it. You can rip it in half and then your will is considered revoked. Fraud is when somebody tricks you into signing a document. So for example, the testator might believe that they're actually signing something else, a deed, a contract, whatever else they think that they're signing, but what's put in front of them is a will, and they're not aware that they're signing a will.
So in order to contest a will, you have to have legal standing to say that the will is no good. In order to have that standing, you have to be what we call adversely affected by the will. Let's say you are one of 2 children of a decedent, and let's just say there is no surviving spouse. If there was no will, then the 2 children would share in inheriting the property. And then let's say there's a will that gives all the property to just one of the children. The other child would be adversely affected by the will because under the will, they receive nothing. If there was no will, they would receive half. So contesting a will is a somewhat complicated process. You do have this opportunity to ask questions, collect documents, depose certain individuals to determine whether you want to object to the will. And then if you decide there's good reason here to actually object, you file what are known as objections. You file them in surrogate's court, and that is the beginning of estate litigation, in this case known as a will contest.